let's talk about the exclusionary rule. Now, this is a common law concept, so this is not in the statutory law. This wasn't passed by Congress. This came from the courts. And we first saw the exclusionary rule in 1914. The court had a federal case, of course, and they were talking about the fact that if law enforcement does not go through the proper procedure to obtain evidence, then they're not going to let you use that evidence against a person at trial. I think that the police had, I can't remember what they had done to Mr. Weeks, but and they also said this part, the fruit of the poisonous tree. So let's just say that I am, I don't know, I am a known drug dealer. And so the police come to my house one day. They don't have a warrant. They don't have anything. And they knock on the door and nobody answers, but the door's not locked. So they just walk on in the house. They don't have a warrant. They don't have consent. No exceptions. They walk in the house. They're walking around. They're looking. They really don't see anything. One of the officers opens a drawer. And in the drawer, there is a key. And it has the name of a facility on it. A storage facility on it. And a number. So they go to the storage facility, open it up, and they find in there just kilos and kilos of cocaine, just front to back. And in the back, there is a body, a dead body for somebody that they have been looking for quite some time. And this person was a rival drug dealer of mine. They know that. So it is quite obvious that I have done something and I have in my control at least felony level amount of cocaine. It is very suspicious, and to say the least, that I have a body in the storage facility, which only I had access to. So, even though it is quite obvious, they still cannot use any of that evidence against me, because the only way that they made their way to that facility and gained access to it was because they did not follow procedure. They did something that was in violation of the law. So if it is illegally seized evidence, you can't use that evidence. You also cannot use any evidence that you wouldn't have gotten any other way. If we look at it in real terms, the exclusionary rule keeps police officers from skirting the law and then taking advantage of it. So this was a well-known and oft-applied doctrine in law enforcement and in courts, in federal courts. So, in the late 50s, there was a case in Ohio, a lady named Dollree Mapp. And they say Dolly, but her Dollree was Dollree's name. Dollree was known to the police. She had lots of professions. She was a hustler. She just did many things, and had lots of friends that were involved in criminal enterprise. So there had been a bombing in the city, and the police had gotten a tip that the suspect was at Dahlry's house. So they go to her house and actually knocked on the door. And I've heard the story so many different ways, but they asked her if they could come in. She told them to hold on, and she actually called her attorney. And her attorney told her, they're standing outside waiting. Her attorney told her, you do not let them in without a warrant. The Madelyn rule. They don't have a warrant, you're not consenting. So the police, after having stood out there all that time, said, oh, we have a warrant. And they flashed around some paper. And so Miss Mapp let them in. They did not find the person that they were looking for. They did not have actual consent. They had deceived her, and they did not have a warrant. Now, while they were searching the house, they found some contraband. One of the things that Miss Mapp did was sold porn, and they found that. They found some drug paraphernalia as well, and they charged her with possession of the lewd material and with possession of drug paraphernalia. She ended up being convicted on the lewd material only. So, notice the year. This is right in the middle of the Warren years. As I told you, attorneys, criminal defense attorneys were appealing right and left. This one was before Miranda. So, which was heard in 1966. In 1961, the case makes it to the Supreme Court, and the Supreme Court applied and incorporated not one of the amendments, but the common law concept of exclusionary rule that came from Weeks. As far as the Warren Court was concerned, they were writing law. They were writing law. So, at this point, they overturned Miss Mapp's conviction, incorporated the exclusionary rule for all states, and said from now on, if you have obtained material in violation of the Fourth Amendment, whether you're a local law enforcement, state law enforcement, and certainly federal, it's been that way since 1914, you cannot use that evidence against the defendant in court. You're going to have to find something else. But you cannot use that evidence against them in court. Couple of exceptions to the exclusionary rule. One of them is good faith exception. So just, say that a police officer had written down a particular address, and when it got printed up, the address on the affidavit, the address on the warrant was different than the address that the officer had requested. So they go to the house that they thought that they had the warrant for, except for a typographical error, and they execute the warrant. So there is a mistake, but that mistake was not the officers, and So they won't hold that against an officer if there's a technicality, and the officer really believed that they had the authorization to do it. Another exception to the exclusionary rule is the inevitable discovery exception. So if they would have found it anyway, then like in my example, eventually somebody was going to smell something, and so maybe they're able to do something with that because it was going to be found. There's also a plain view exception to the exclusionary rule. So you have not done any bad police work. It was right out in the open. So that is another exception. All right, let's talk about the Sixth Amendment. I always like to show a picture of Clarence Earl Gideon. Clarence Earl Gideon was he was he had been in and out of jail. Let's just say it that way. And he was charged with burglary of a pool hall. Burglary. And he was in Florida. He was in Florida. And when he when they asked him if he wanted to plead guilty, he said no. And he said that he wanted to go to trial. Well, they said that's fine. That's fine. But they would not give him an attorney. He couldn't afford an attorney. He couldn't afford one. So notice the year. This is 1963. And there was no requirement that attorneys be provided because the Sixth Amendment had not been incorporated yet. So the requirement that you have an attorney, that you get an attorney provided for you, even if you can't afford one, is Sixth Amendment. It only applied in federal cases until this. Now, Mr. Gideon got railroaded. From the way that it has been described, the case against him was very weak, but he didn't know the court proceedings, and he ended up being convicted. So he goes to prison, and he starts reading and while he's in prison, and he looks and he sees the Sixth Amendment, and he's like, wow, that would have been really great if I had had an attorney. He gets some paper. He hand wrote a petition, and it basically just said, what happened to me wasn't fair. And I don't think that it is fair that just because I'm indigent and because I couldn't afford one, that I didn't get an attorney because I didn't understand what was happening. So this handwritten petition makes it to the Supreme Court. And Earl Warren and all of the Blackburn and the other judges, not only did they accept the case with this handwritten petition, they got an attorney to argue the case for Mr. Clarence Earl Gideon before the Supreme Court and waived all his fees. So this attorney argues the case in court, and the court, the Warren court, decided that attorneys are necessities, not luxuries, and mandated that at all levels, for everything really except Class C misdemeanors, tickets where there's no possible jail time. If a person cannot afford an attorney, then the government is going to have to find a way to provide an attorney for them. So that's county court, that's district court, that is all levels of court, even state court, where all that is before you is a violation of a state law or a question of a violation of a state law. You still get an attorney. And that is all because of Clarence Earl Gideon. Now, Clarence Earl Gideon did not get any compensation for being wrongly convicted. He did get let out of jail. He never got any money, but he is, and my understanding is that he died without having much money, died a pauper. But he wasn't in jail. And he changed the face of jurisprudence through his little handwritten petition. Case Gideon versus Wainwright. Sixth Amendment, right to an attorney. Sixth Amendment also guarantees a speedy and public trial. It also guarantees a right to confront witnesses, and it guarantees a jury of your peers if you want one. So finally, let's discuss the Eighth Amendment. Eighth Amendment prohibits cruel and unusual punishment, excessive bail, and excessive fines. It is super short. It just says you can't do it. What does cruel and unusual punishment mean? Because we didn't get any direction from the founders as they were writing the Bill of Rights, because all they said is you can't have cruel and unusual punishment, you can't have excessive bail, you can't have excessive fines. So really that left it up to the courts to interpret what that meant. Really quickly, it was established that basically we're saying that the punishment has to fit the crime. The bail has to fit the crime. You literally cannot put somebody to death because they stole a chicken. Disproportionate, if the punishment is disproportionate to the offense, punishment doesn't fit the crime, that violates fundamental standards of good conscience and fairness and is unnecessarily cruel. All right, so punishment doesn't fit the crime. So the question is, what is unnecessarily cruel? You have to know that there have been cases and cases and cases where people have said the death penalty is unnecessarily cruel. And over again, the Supreme Court has said, no, not the death penalty itself. And if a state decides that they want to give the death penalty, they definitely have the right to do that. Now, they have had some examination of who is given the death penalty. And one of the things that they have said is that if we're not 100% sure that a person was able to form a complete understanding of what they did and the consequences of what they did, then we are not going to put them to death. So people that fall into that category, if you were under 18, doesn't matter what it was, if you were under 18 the time the crime was committed, then you cannot get the death penalty in the United States. That is considered cruel and unusual punishment. If you are mentally ill, or if you have a low IQ, you cannot get the death penalty in the United States. There was a recent case where Florida was giving an IQ test, And so whatever the cutoff was, the guy scored 1 point above the cutoff. And they were like, well, you passed, so death penalty for you. And he appealed, and they told Florida and basically all the states that you're not going to be able to do one IQ test. There has to be a full assessment if there's a question. Several experts and probably more than one test are going to have to do an assessment to make sure that it is not that arbitrary. So mentally ill or mentally incapacitated, you are not able to get the death penalty. They also will not allow someone that was under 18 at the time the crime was committed to get life in prison without the possibility of parole. So juveniles cannot get that. They can be tried as adults. In Texas, you can be tried as an adult as young as 14, but can't get the death penalty and can't have a sentence of life in prison without the possibility of parole. Now, the death penalty itself really has been around for centuries, and all the colonies had some form of death penalty. The United States today, though, is the only Western nation that still is using the death penalty as a crime. Nowhere in Europe. I don't know if Australia is considered Western, but just nobody else. But there are, states get to decide, and there are some states that don't allow the death penalty. There are some states that allow the death penalty but don't use it. California is one of those. And then there's Texas and Oklahoma and Arizona and Florida that do allow the death penalty and use it all of the time. Texas by far out is the top distributor. I don't know what the word is. Leads the nation in the number of executions each year. I don't think this cartoonist thinks much of Texans. There's been a lot of debate about the death penalty. I do need to let you know that there was a period of time in 1972. A case gets to the Supreme Court. It's called Furman versus Georgia. Now, to see this, you need to look in the notes of the PowerPoint. Furman versus Georgia. And the NAACP and several organizations, ACLU as well, basically were showing statistics that were showing that disproportionately, especially in the South, but disproportionately across the entire United States, African American males, and those that were not very well off, were disproportionately being put to death. And so the court said, okay, nobody can put anybody to death because this is disturbing. And y'all are going to have to go back and work on the arbitrariness and the discrimination that we are finding in the use of the death penalty. About 3 years later, a case was filed, and states had made changes. So, like, you cannot have a judge decide the death penalty. You have to have a jury case. Most states require automatic appeal of death penalty cases so that they can be reviewed. There are all kinds of arguments that you can make. You have the right to file a writ of habeas corpus, explaining that there were problems in the way that you were prosecuted, or the way that the people that investigated you, or anything that you can find. So there are all kinds of safeguards in place today. And so in 1976, the Supreme Court allowed the death penalty to start again. But there was a 4-year period from 1972 to 1976 when there was a moratorium on using the death penalty. There's also a debate about what forms or what methods can be used to put someone to death. All the states that allow it allow lethal injection, but that has come under fire as well. A lot of pharmaceutical companies are based in Europe, and so they will not sell any drug that can be used to put someone to death to any state or the federal government, for that matter, in the United States. A lot of states have backups in case lethal injection ever gets declared unconstitutional. A couple of states still have firing squad, Utah and Oklahoma. There's a couple of states that still have hanging, but all of them have lethal injection as the first choice. So as we look at the process look at due process, we have talked about being questioned before you start a case. We have talked about the process of leading up to a case with the exclusionary rule. We've talked about the Miranda rule. We have talked about the actual trial. You get to have an attorney. You get to have a speedy trial. And we've talked about sentencing through the 8th Amendment. There is I guess the last part of due process is that there's still not a guarantee of an appeal unless you have the death penalty, and then it's all automatically appealed. So that part, so you don't have a guarantee, and we'll talk when we talk about the federal court system about why that is and how the court system is set up. Supreme Court rulings have affected police practices. Miranda versus Arizona really changed policing and the way policing worked. Constitutional rights are still to this day, I'm not going to spend a whole bunch of time on this, but they are still to this day unevenly applied. There are documented cases of racial profiling. There are documented cases that minorities are much more likely to be victims of police violence. And this was written way before 2020, when we have seen face evidence of this issue. People like to hear that someone is tough on crime, but prison overcrowding is an issue. We have disproportionate amounts of people in prison compared to other countries. The United States is the world leader in terms of the number of people that are placed behind bars. 698 inmates per 100,000. The next closest is Cuba with 510. So we have issues and questions about our criminal justice system. our answer to everything seems to be put them in jail. I really would like to spend a lot of time on, because it is very interesting, to talk about terrorism, but our time is short. Our time is short. So I'm going to go through this really quickly. This is not on the midterm, but there will be questions about this on the final. So just want to let you know that after 9/11, the United States changed their policy on interrogations, on arraignment, on speedy trials, on the right to counsel. And if you got a label, whether you were a United States citizen or not, if you got a label as an enemy combatant or a material witness, the United States government could and did round you up. A lot of people are still, to this day, in 2020, in Guantanamo Bay Detention Center, never had a hearing, never had a trial, never had an attorney, never knew what charges were against them. They weren't able to file writs of habeas corpus. To get the government to explain what evidence they had that let them hold them. A couple of times when the people were United States citizens, the court said, you are going to have to give this person an attorney. You're going to have to let them know what the charges are. But if they were not United, so that was Hamdi versus Rumsfeld and Hamdan versus Rumsfeld. But other than that, people are still just sitting there. The Patriot Act was eventually passed. The Patriot Act really allowed the security agencies to get warrants. Well, at first they weren't even getting warrants. They were doing warrantless searches. They were searching your social media. They were following you. They were tapping your phones. If they suspected that you had some ties to terrorism. And so they would just, you get that label. The program was leaked by a guy named Edward Snowden. Mr. Snowden is in Russia. I saw an interview with him the other day. He is in Russia. Russia is giving him asylum. He has charges pending, but he has been away since he leaked what the United States was doing. The law now is that you do have to get a warrant before you can conduct these types of surveillance. This social media wiretapping. They have special courts that are designed to, you give them the evidence and they decide, yes, you can do it. And I think they're called FISA courts, but I don't know what FISA stands for. Federal FISA courts. FISA, I know that. And if you get a warrant, then you can go and basically do all the things that we have just talked about you not being able to do. You can search a person's house, you can tap their phones, you can listen, you can follow them, you can put GPS devices, you can search their computers, all of it in the name of security. It's a tough one. It's a tough one because we want to be secure. We do. I don't know, and this is Madelyn talking, it's not in the book. I don't know if completely blowing through the guarantees of the Bill of Rights is the way to do it. I say put people on trial. Go ahead and put them on trial. The last thing that I'm going to say is that the guarantees of a fair trial, right to have an attorney, are not limited to United States citizens. They are not. If you are going through the American court system, now we're just setting aside questions about whether or not you can legally stay in the United States. That's a completely different system. But if you are going through the criminal justice system, then you get all these rights. You don't have to be a citizen. You get arrested if you get charged with the crime. Well, if you get arrested, you get to have your Miranda rights read to you. You get the right to have an attorney if you can't afford one. You get charged with the crime, then the bail cannot be excessive. If they gather information that is not legal, then the exclusionary rule still applies. It doesn't matter if you're a citizen or not. They have to follow the rules of evidence when they are in a trial, and your punishment cannot be worse because you're not a citizen. So citizenship is not the trigger for rights of criminal defendants. So that is it on the rights of criminal defendants, and that is it for chapter 4.